Well, then, here we are. And I thought I would do a quick video. Is it ever really? Who knows? Hopefully you can hear me. Thought I'd do a quick little video about just navigating family court, sort of a detailed guide for litigants who are going through family court by themselves and without a solicitor, which would be mainly men, but just there may be some women. But yes, I just wanted to welcome you all, first of all, to our comprehensive guide to getting family court. Whether your case is straightforward or complex, knowing the steps and key terminologies will empower you to represent yourself effectively. And hopefully, this video will help you do that. So let's get started. So, first of all, you need to understanding court steps, the process, what you need to do. Let's go for non-complex and complex cases. We'll start with non-complex cases. Initial filing, you'll file the paperwork. What that is, obviously, you start your filing the application with the family court. Most common forms in this situation would be the C100 form, child arrangements application, specifying who the child will live with and who the child will sign with. Form A of the financial orders following divorce, or you may even have received a non-molestation order application. You'd be on the receiving end of that. This is top level, top line stuff. It's not going to be, this won't fit every single person and every single situation, but it will fit a fair few. You also need to get your supporting documents ready. So ensuring that you've got ensuring that you provide all your required supporting documents, which may include, in some cases, the birth certificates, medical history, marriage certificates, bank statements, all relevant evidence that you may have that you are defend yourself ultimately against any false allegations. There'll be safeguarding checks completed. That's the role of CAFCAS, the Children and Family Court Advisory and Support Service. They conduct safeguarding checks. They check for any immediate risks to the child. And they could say a risk to the child would be something from 10 years ago, a driver from 10 years ago. That could be a risk to the child. They can make a risk up to the child in any way, shape or form. Let's be clear on that. CAFCAS will contact partially by the phone to conduct the initial telephone interview and perform the background checks on the National Police database computer. Normally, you'd get your safeguarding interview, which is, in my view, more important than your court date. But then you'll get your first hearing dispute resolution or your directions appointment hearing. This is the first where the aim is to identify issues and see if anything can be reached at this stage. And the magistrates or judges will always the good judges and the good magistrates will always try and mediate both of you. And that's something the solicitors should be doing if they've got a solicitor. But generally the solicitors won't be doing that because they want to get legal aid. They want to get money out of you for legal aid. So, the aim is to identify and see if any agreement can be reached. You will attend this hearing, unless it says it's a non-in-person hearing, in which case it could be a CVP, or it could just be a paper hearing. But you, the other party, CAFCAS officer may well be there, a judge or magistrate or legal advisor. That's who will have the potential hearing. The outcome possibilities. So you'll put a statement of issues in there, both settlement of issues amicably, directions for further steps if issues cannot be resolved. If there's further hearings, if an agreement can't be reached, directions on gathering evidence will be provided. You may be required to submit witness statements, undergo mediation, or respond to specific queries or allegations that are coming your way. There will then be a final hearing. The aim of this would be to consider all evidence and make a binding decision. Now, preparation for this is obviously key, really important. So being ready with all the documents, evidence, and a clear statement of your desired outcomes and reasons for these outcomes is really important. Now, step 2, steps for a complex case. So this is sort of much more complex case. Yeah, so you're going to have case management here. So the purpose of the case management hearings are to organise the steps, timetable, and procedures in the case to make sure everyone knows what they're doing. The directions issued, these may include the need for additional reports for specific evidence like medical or psychological evaluations. Section 7 report, now this is quite a standard report and will be issued and ordered in most cases when there's hostility. When ordered, there needs to have a thorough understanding of the child's welfare. The process for this, Section 7, is conducted by a CAS officer or the local authority. These involve interviews parties, including the children and any others, i.e. teachers, support workers, that sort of thing. The report includes recommendations on the child arrangements, and the next thing it gives the court a clear idea and a sense of direction as to what they should be doing. When it's ordered, if there's a concern, care or supervision may not be necessary. Process, obviously the local authority conducts the investigation. The aim is to determine the children, if the children are at risk and if protective measures are warranted. You've also got the Section 47, when the purpose of this is initiated. When this is initiated, you should be scared, you should be fearful. It's initiated to assess potential and significant harm to the child or children. The process, again, local authority will undertake this through thorough investigation, or CAFCAS could do it. The obviously can have social workers, police, health professionals, doctors, teachers. The recommendations may lead to child protection interventions, which really opens the door to foster care. The purpose of these is to obviously try and get to the bottom of the allegations from each party, really, and trying to cut between the ship. Ultimately, that's what it's trying to do. Because otherwise, you're going to be quite angry. You're going to be angry. She's going to be angry, and we don't want anger. We need to lose that anger when you're going in family court. I'll explain why in shortly. But let's not forget the, how can you put it, CAFCAS officer involved when we're doing the Section 7. This is more complex cases. Now, each of these hour-long hearings that you're going to go to, they're generally a bit of a waste of time, to be honest with you. The only people who are going to get benefit from them because it makes them feel like they're doing their job. It gives them a purpose. So there will be directions issued. These may include the need for additional reports, like I said, specific evidence, medical, psychological evaluations. When the Section 7 is ordered, the court needs to obviously have a thorough understanding of the child welfare, conducted by either social services or the CAFCAS officer. This is a more in-depth interview. It should ideally be in person as well, and they should see you with your child. How can they make recommendations on what you should be like, how you parent, if they can't see you with the child, and what you're parenting? So Section 37 just said about that. Basically, is opening the doors to foster care, and that's not a report or assessment to be part of at all. So once the process is started, the local authority conducts the investigation, or CAFCAS will conduct the investigation. The report aims to determine if the child is at risk and if protective measures are warranted. And Section 47 is initiated to assess potential to the child or children. Now, the process again is the local authority or CAFCAS take the thorough investigation. It can involve other social workers, care professionals, and teachers. The recommendations again may lead to child protection interventions, which basically means foster care. You've then got the finding of facts hearings. Finding of facts hearing is the purpose of these is to resolve disputed allegations, e.g., the abuse or neglect from both parties or to each other, or whatever the allegations are. The process of this is must present their evidence and witnesses to establish the facts. A judge or magistrates will make a decision based on what you have to say. The outcome of the court determines determinations on the facts which will influence some decisions. So expert evidence, i.e. psychological assessments, that sort of thing, when used, if a specialised knowledge is needed, psychological assessments, that's when they'll come in. The types of experts you get is medical professionals, psychologists, social workers, you name it, there's probably an expert for anything if you need it. So then you've got the final hearing. So the duration of this can take several days. It can be a day. If it's complex, it's going to be more than 2 days, 2 days or more. The process obviously is a comprehensive review of all the evidence, expert testimony, and arguments from both parties. The judge will make a final decision, and it's legally binding, and the decision will be what sides or she decides. Now, some key information and definitions. The Section 7 report. The purpose is to assess child's welfare and provide recommendations to the court. It's CAFCAS or the local authority that prepare this report, and they complete interviews with the child, parents, and others, school, medical, etc., and makes these recommendations to the court based on what they find. Section 37 its purpose is to decide if the local authority should intervene more intensively through care or supervision orders. It's a local authority or CAFCAS that will prepare this document, and it's a deep investigation into the child's welfare, family background, and any risk assessments. Section 47 report. Now, this purpose is to assess if the child is at significant harm and outline protective measures. Now, who prepares this again? It's the local authority and children's services. The content is basically thorough investment, including interviews, home visits, and multi-agency collaboration. The importance of the interviews is you'll never actually appreciate until you've actually gone through it and you've seen through it. Then you go to court, and then you hear the judge or magistrates say the same thing and do very little if circumstances prevent it. So they will quickly identify and address any risks to the child. There are questions about the family dynamics, any history of abuse, and concerns about the child's well-being. The impact of this is obviously the information helps court to understand any immediate concerns that may need. Number 4 would be the court officials. Now, who's who in the world of family court? So you've obviously got the ushers, security guard thing, but you've got also legal advisors and magistrates. Now, magistrates are lay volunteers with no formal legal qualifications. That's why you'll always have a legal advisor sat in front of telling them what they can and can't do. Now, you've also got the legal advisors, as I say, they're magistrates. They ensure they follow the legal principles. They do not make decisions, but they provide all legal guidance. Then you've got your district judges, which is I prefer to go in dealing straight off with a district judge, straight up, rather than a legal advisor or magistrates, because they can get the job done much quicker. They're legally qualified professionals with extensive experience in family law. They handle more complex cases and have a more in-depth legal understanding than magistrates. Decision making is, well, they make the findings and legal rulings as a result of any hearings. The qualification like judges, because they're senior judges, you see, come to the district judge with significant experience and expertise. They deal with the most complex cases, and they typically preside over longer and more complex hearings, including multi-day trials, so their decision making gets distorted. Now, you may even have to respond to a non-molestation order after served upon you. Now, you've got to understand carefully. The restrictions imposed and their implications are huge. It may be an undertaking, it may be undertaken, or you may have accepted the order itself, non-molestation order itself. I believe we should be contesting any false allegations on any non-molestation order. It gives the other party to contest the order, present evidence to argue against what you requested. They request adjournment, so if someone wants to request an adjournment, if they are unprepared, you can make a request. More time we gathered, evidence will be prepared for your defence. Prepare evidence, gather any text messages, emails, witnesses, or evidence that supports you in your case. You've also got the applications and orders. The C2 application, which we're going to cover. Basically, C2 is a form that gives you the ability to add existing problems or existing issues to an existing case. And I've no doubt that if you're holding the child, then the other party will be making a request to the court as an immediate court order, as an immediate request, and you have to be sort of specifically there and then, right when she needs you. So the common uses for a C2 application is to seek permission for expert evidence. That's one thing they do. To request or extension of existing orders. That's something else. To clarify the procedural matters or request court actions. You've got an enforcement order. This is something that most people will use if the relationship is toxic, and you will know if it's toxic or not. I would have told you, or you could feel it yourself. When it fails to comply with a court order, such as a child arrangements order, unpaid work will be served because there needs to be a consequence to their failure to adhere. Things that would have been agreed. So the process is, so you'd file an application for the Child Arrangements Order. You'd file an application for the Child Arrangements Act, Children's Act 1989. The court may issue various enforcements or measures, including fines, community service, or in extreme cases, you'll have your hearing, which you'll need to attend, either with DVP, where you can present your evidence in your case of non-compliance, whether it's an enforcement order or whether it's a fresh application, but you always will get a chance to present your application evidence. In conclusion, well, navigating family court can be initially overwhelming, and it's not easy, especially for litigants in person. However, with a clear understanding of the steps involved, key reports, and the roles of which various court officials take within the theatre of family and how to respond to specific orders, you can effectively represent yourself. Preparation and knowledge are they're powerful tools that can significantly benefit your case. If this guide has been just in a tiniest little bit, then don't forget to like, share, and for more comprehensive legal insights. Back to the topic on hand. So hopefully you're still with us. See what we're in. It's in 5 minutes in, whatever it is, and hopefully we've still got people watching there still. And hopefully this will be making sense to you. In family court, whether it's your case or someone else's, it's never straightforward or as complex as may seem nice and easy, but something happens which takes it all out of kilter. Let's try and get into the details of understanding what happens when you file your application in the first instance to family court. Now, let's rewind that for a second, actually. Out on bail, and previously you'd been allowed to see your children and with your ex-partner, and then suddenly she's changed. She doesn't want you seeing the child at all. And then she's using the criminal side of everything as a reason to stop in contact, which is, again, a little bit harsh. But you've got to trust no one, especially your ex-partner in this situation. You may love her still, but you cannot trust her or him. To clarify procedural errors or procedural matters and specific court actions, enforcement orders are used when parties comply with the order, obviously. A court, such as a child arrangements order. Now, you can ask for a penal notice to be attached on your first time back in court. We are talking about all sorts of nonsense. During the hearing, you'll need to attend the hearing, obviously. But how you participate in that and what you do will eventually have the outcome of your court case. If you say it's all against you, if you say it's all wrong, that's what will happen. Navigating family court can initially seem overwhelming, especially for litigants in person. However, with a clear understanding of the steps involved, key reports, the roles of various court officials, and how on to specific orders, you can effectively represent. Preparation and knowledge are powerful tools that can significantly benefit your case. If this guide has been the slightest little bit of help towards you, don't forget to share it and subscribe for more comprehensive, real-time legal insights from my perspective and my perspective. Whether things may seem straightforward or you think they're going to be straightforward, something generally will come out of the woodwork and make sure that it's not as straightforward as what it should be. Now, let's get into some more details. You initially file your application with the family court. That's what you're going to have to spend some time at media, even if it's just one session. Ideally, you want to be avoiding court at all costs. But if you need to go back there, then obviously we go back. I think that if she's got any sense after this next hearing, then she will stop doing what she's doing, because it's clear to everyone else, a blind person, it's clear to them what she's doing. So make sure you've got all supporting documents, maybe a birth certificate, a marriage certificate, divorce certificate, any relevant evidence that you think is relevant, and then we will make a decision as to what's important and what goes in early and what doesn't. Because we don't want to give them too much information, because it means they'll be able to concoct their stories and try and make them line up with yours. The solicitors are clearly snakes that is on the other side of this, clearly. What to expect from CAFCAS? Well, CAFCAS will contact both parties, usually to conduct initial interviews and perform background checks. Can you put this? CAFCAS are not qualified, psychologically, they're not qualified to spot parental alienation. They've got a toolkit that they use that's not, unless you point it out, like a really, really obvious and blatant point out, then they take on board what you have to say, ultimately. That's the truth of the matter. That is the truth. Yeah? So, once you've had your court paperwork come through, you need to make sure that you are doing the right things in terms of leading up to court and treating your ex-partner with respect Now, this may be scoffed at and laughed at by us watching this right now. You might be asking, how can you get on with your ex when she's done this to you? How can you do that when she's done it? I get it. I know. I've been there. And it's not easy. I have to respect my ex-wife, even though she does not respect me and doesn't see the value of what I do and how I bring myself to do what I do for other people. She just sees a version of me that she doesn't like and doesn't want to like, because she's been traumatized as a child for something else, basically sexual assault on her and her auntie Claire, basically, and the whole family knew about it, and no one did fuck all apart from me. And all I did was say I don't want my daughter being left alone with her uncle. Why was that? Judge says, well, because he sexually abused my ex-wife, Miss, and Auntie Claire. My ex-missus flipped her lid. All I was doing was protecting Nyla, and she flipped it. And she's like, "Oh, why would she not be able to protect Lila?" I'm not being funny. She was not being able to protect Lila. I mean, she gets beaten up. From the moment that Ryan steps foot into that house, that's when she's not able to the daughter. That's why. That's when. And that's how. So keep the professionals on side with this, yeah? Again, Section 37s and Section 47s, they're quite scary, because that does open the door. It does open potential foster care, and that is shit, because you've got foster care coming, the police will come and take your kids. There was a big incident in Leeds last night, and it's still going on again today. The police, ultimately. And if you don't want that, then you've got to try and find a way of giving them what they want without giving them your kids, which you have to jump through hoops of fire. That's what you have to do, because if they want your kids, they will find a way of getting them. They will find a way. The process is for all of this is the local authority or CAFCAS will undertake thorough investigations. These can take up to 16 weeks at the moment. That was a couple of weeks ago, so it may have increased by then. But yeah, I think I've covered most points now that I think you need to cover. You're going to have your normal lessons at school? No? In your form, you have normal lessons? I don't know. But obviously, when you've got the complex cases, how long hearings can go on for, every 3 months will go on for a long, long time. And every time you go to court, you're thinking, oh, we're going to have to get something's going to get resolved now, and gets resolved. Apart from you not seeing your child. And how does that make sense when I've got dads who have been prevented from seeing the children based on false allegations. Yet the mums who accused them of these false allegations are now going out in the way that they allege their husbands or boyfriends to be behaving like. They're projecting. And that is what I've noticed with a lot of women. But anyway, the duration of these on the phone can generally last about 30 minutes to 45 minutes. They can take up to several days. If they start with you, then go speak to the ex. Who knows? Generally, they will speak to the mum first of all, then they'll come to you afterwards, because she's the one caring for the child mainly. The judge makes all the final decisions, apparently, so they say they're legally binding decisions. So, any key information and definitions that you may want is Section 7 report. The purpose is to assess the child's welfare and provide who prepares the CAFCAS or authority, who prepares the report. So basically it'll be CAFCAS or the local authority dealing with the case more frequently. That's who will be dealing with your paperwork. Section 37 again opens the door to potential foster. If they decide the local authority should intervene more intensively, e.g. through the care of supervision orders, then that's what they will do. But then they have to have legitimate court orders, because a lot of what they've been given out are not legitimate and real court orders. Anyone with a piece of paper and say this is a court order, but there's no signature, there's no case number, there's nothing on there that supports them saying that what they have is an actual court order. Anyone could make that up, anyone could print that off, anyone could do anything. Anyone could be doing literally anything. Now there's questions about the dynamics that the CAFCAS will naturally ask: any history of violence or abuse, and concerns around the child's well-being. The impact of The information helps the courts understand any immediate concerns that need addressing. It helps the court officials who's who, the legal advisors and the magistrates and circuit judges. You've got lay volunteers with no formal legal qualification, guided by the legal qualified advisor. And matters of the law, there's legal advisors in the realm of family courts, and legal advisors are probably the bottom of the pile, but probably probably more knowledgeable than most of the others. But they're at the bottom of the pile. So, but they ensure magistrates follow the legal precedents. They do not make decisions but they make critical legal guidance. District judges' qualifications are legally qualified professionals with extensive experience in family. The role is to handle more complex cases and have a more in-depth legal understanding than magistrates. And it's going to be quite important as well, because obviously making decisions is part of what we do on a daily basis. They make findings directly. They can do, yes, they can. They might get at the end of the hearing if they've got time, or they do it they pull you in to do like an hour beforehand by a CVP. I can actually think of the non-molestation order upon being served. Now, understanding that it was imposed on their implications based on, can't do anything new. Typically, actions consent without agree to the order without admitting guilt, contest the order, present evidence and arguments against the order, request an adjournment if you can request more time to gather evidence and prepare your defence and prepare evidence. Gather any text messages, email messages, any other evidence that supports your case. Applications and orders. So you hear C2 being banded around quite regularly. This is for seeking permission to expert evidence, request a variation to the extension of existing court orders, to clarify procedures or request specific court action. Enforcement order, which is what we want as well, when used, is when a party fails to comply with the court order, such as the child arrangements order. This is different skill sets or speaks a different language. So the process for child arrangements was application under the Children Act 1989, Section 11J. Court enforcement measures, including community service or, on extreme cases, imprisonment, will be served out. You will need to be attending a hearing where you can be present of all the non-compliance. And ultimately, let's be honest, navigating family court can initially seem overwhelming because of the image we have in our head about it all, which is wrong. Especially for litigants in person, with a clear understanding of the steps involved, key reports and the roles of various court officials, and now how to respond to specific orders, you can effectively represent yourselves. Preparation and knowledge are powerful tools that can significantly benefit your case. In this guide, hopefully it's been, don't forget to like and share and subscribe for more comprehensive legal insights. Until next time, peace and love, Lana's glove.